Hello, welcome back to my channel. I've just woken up and seen that there was new documents filed. I had a big day yesterday. I worked at the Melbourne Cup and it was pretty physically taxing. So we've got some interesting things that have occurred in this case. But I note that there is still no answer replied yet. And there looks like they are trying very hard to say and still work on the fact that 7M have not uh, haven't responded, and therefore are doing everything wrong, where we know that it was the court that actually it was the court that said, hey, you've not filed a response, you get a default judgment. So I've got to give her some credit for trying. The other interesting thing is, and I hope that you can still see me because I'm just trying to open up all the tabs at the moment, is that there is a new lawyer on file. And on the Twitter spheres, she's a family lawyer. So everyone's talking about the fact that she's a family lawyer on Twitter. So as opposed to an estate lawyer. So I don't know. So let's have a look at this and see what we're dealing with. Okay. So there were four. There's several documents filed. I apologize if I'm all over the place as well. As I said, I'm not. So we've got a notice of appearance, notice of motion and motion, a memorandum, and an affidavit of the attorney. So let's have a look. So we've got the notice of appearance, that the counsel shall appear as counsel on record for defendants and without a crystal ball. Well, here's the thing. Well, it wasn't the restraining order as such, Christine. It was the notice to dismiss. She filed a notice of dismiss. And the problem with that is that if they had provided discovery, and she had won the notice, and she'd won the notice to dismiss, it was all going to be, it would have been wasted time and money. They wanted to see whether it was actually going to, if she was going to actually get her motion. Now, once her motion was dismissed, she had to reply. She then had to respond. And that's when, and don't forget, they tried to contact the court to say, hey, they tried to contact the court and said, hey, we've got a problem here. We need to reset this. And they said, well, you've got to file a motion. And so they filed the motion. So if there is a motion in play regarding discovery, I'm still struggling to work out how then KJ can then go and ask them to compel because of that fact. Because there's a motion. The motion hasn't been ruled on. If 7M loses their motion, then they are compelled to discovery, right? But if they win their motion, they get an extension of time. And this, again, is a wasted money. It's really bizarre, in my opinion. This is a really, really bizarre situation. And seriously, to use the old cliche, in my opinion, they're flogging a dead horse. Now, it's also a lawyer's responsibility to ensure that that your client is not wasting frivolous money filing frivolous suits. Now, because that motion is already determined for discovery for November 21, to me, this is a waste of money. And I hope the judge absolutely rips into him, into the lawyer, because as I said, the motion is already on foot. 7M has already filed an extension of time motion. A date has already been set. The one motion that they should be actually worried about is the default motion. Yes, that's right. Apparently, the new attorney is a divorce attorney. That is correct. So here is, let's look at this motion, and you'll see my point. So 7M Films versus, Catherine Mansky-Polson, plaintiffs and their attorneys. Notice of motion. Please take note that on November 21, 2022 at 1:30 p.m., at a place to be determined, defendants Catherine Mansky-Polson without a crystal ball will bring the following motion on for hearing before the Honourable. Isn't it Michelle? They've got Michael. It's Michelle. Or Mikal. It's Michelle. Come on. They can't even spell it right. There's an E there. Michelle. Just so to show you, I'll enlarge this. Gee whiz, do you know how much trouble we get into if we make mistakes like this? Michele. And they've put Michel. That to me is the first strike. That's right, Christine. That's a really good way to upset a judge. So they want the court to order compelling plaintiffs to immediately provide answers to defendants' first set of interrogatories and requests to produce documents served upon plaintiffs on August 26, 2022. So they're doing a motion to compel, awarding the defendants their costs and attorney fees. This motion for dismissal. And what? It's hang on. Awarding defendants their costs and attorney. This motion for dismissal is made pursuant. It's not a motion to dismiss, you tool. It's a notice to compel. It's not a motion to dismiss. It's a motion to dismiss, not a motion to compel. They've just copied and pasted. Oh, dear me. I'm going to change the title. Anyway, that is where we are at the moment. Okay. That, to me, if I was 7M's lawyers, my response would be, we're not sure whether this is a motion to compel or a motion to dismiss, because point 1 of the motion and point 2 of the motion actually contradict each other. Okay, so this is the defendant's memorandum of law supporting motion to compel and opposing motion for protective order. Oh, they decide to respond now. But remember also, they've still not answered the claim. Defendants ask the court to issue an order requiring plaintiffs to respond to discovery that was served on August 5, 2023. Also, what's really tacky is you can see the edit lines here. And which remain in outstanding plaintiff's excuse for refusing to respond to discovery is that they have been seeking a protective order. However, plaintiff's requested protective order is so broad that it would render the process of discovery completely meaningless, in that defendants would not be able to assist counsel in preparing the matter for trial. Moreover, much of the materials plaintiffs seek to protect under the proposed protective order are not remotely connected for their concern for privacy. For these reasons, the court asks the court to deny the plaintiff's motion for protective order and grant defendants' motion to compel discovery. Again, in my opinion, this is just a big fat waste of court resources and time, in my opinion. Because as I said, if 7M get their extension of discovery, the whole timeline gets reset and a new lot is safe. On October 5, defendant served its first set of interrogatories and requests for productions of documents. More declarations ABC. Plaintiff has not responded. On August 26, plaintiffs brought their motion for protective order, seeking to sequester all discovery at the office of the plaintiffs, limit access to discovery material solely to defendant's attorney, and provide that depositions be confidential and not disclosed to anyone other than the parties and counsels. So again, they're saying that they served their first request for documents. October 26th, the response from the defendants was, the response from the plaintiffs was, we want to have a hearing to see whether we can get this. So on September 1, court counsel indicated they would not be responding to any discovery request until an order issues on its motion for protective order is decided. So again, they've put a motion in that has to be ruled. The ruling of that motion will then determine discovery. Here's their argument. Defendant's discovery request seeks materials that are relevant and necessary to prepare its defense in this matter. So it says permits discovery to be made any non-privileged matter that is relevant to any party's claim or defense and proportional to the need of the case, considering the importance of the issues at stake in the action and the amount in controversy, the party's relative cost to relevant information, the party's resources, the importance of discovery in resolving issues, and whether the burden of expense of the proposed discovery outweighs its likely benefit. A party's failure to timely to respond to interrogatories or make objections waives all objections except those related to privileged, work product, and expert's conclusion. And then they've got their case here. But regardless of the effect the plaintiff's failure to respond has on their own eventual responses and objections, their failure to respond to discovery, and even the objections thereto, places defendants at a disadvantage with respect to establishing the discoverability of information under the rules. However, the defendants' discovery requests were tailored specifically towards the claims made by the plaintiffs in the amended complaint. Here's the other issue. Well, that's true, but here's the other issue, right? So they're saying that they want records to the amended complaint, right? She's not filed a defense. How does 7M actually know what they need? How can 7M request what documents they need if KJ's never actually defended the thing? She filed a motion to dismiss. So technically, 7M is at a disadvantage because there's no defense filed. They have no idea what she's relying on to defend herself, and therefore they can't ask for the documents. Hello, Will, how are you? So, and of course, remember, this is all about KJ saying we can't do our case because we don't have documents. forgetting the fact that she's never actually defended. There is no answer. She filed a motion to dismiss, which failed. There was no defense in there. And if you remember, when the judge gave her ruling on the motion to defense, the judge stated there had been no defense filed. Right? So the judge in the motion to dismiss, right, says there's been no defense filed. She's admitted to it. If you don't put in a defense, right, you have no right to ask for anything. Anyway, so they're saying the defendant's discovery requests were tailored specifically towards the claims that were made by the plaintiffs in the amended defense. And my point is that 7M have got nothing from KJ in the line of a defense to know what she's using to rely on her arguments. How are they going to argue? How can 7M prove? Well, I mean, we know what 7M is going to prove, but at the moment, you've got an unfair fight, if you want to be technical. KJ knows, or her lawyers know exactly the arguments that 7M are going to put forward, right? But 7M have no idea what on earth they're going to use for their defense. So here is what they were saying that they wanted. Identify all persons who provided answers or other information in regarding responding to these interrogatories, and for each person state the specific interrogatory or interrogatory to which such persons provided information or answers. Identify all persons known to you to have discoverable knowledge, information, and documents that relate in any way to the allegations and claims set forth to the complaint or answer and counterclaim. Remember, the counterclaim was... Well, as I said, it was the court that put the default judgment there. Or the subject matter of this litigation. For each person, identify the subject or subjects of information. List the names of persons referred to in your answers to interrogatories 1 and 2 who you interviewed and state the time and place and location. Have you taken or received any statements related to the matters alleged in the complaint? If so, identify each person. State the date and time. Identify the person. State whether the person has provided copies. State the names and addresses of each and every witness you propose to call in the trial. Identify all persons other than your attorney with whom you've communicated about this issue. Identify all persons other than your attorney with whom you communicated about defendants, giving date, subject matter, and mode of communication. Could you imagine if they had to do that for KJ? Exactly, Holly. Document request once. All statements and Identify all communications, emails, notes, letters, memorandum prior to commencement of litigation exchanged between parties to this litigation. No, they don't have to. What does the communications between Robert Shin and the Derricks have to do with the case? All statements and documents, electronically stored emails, and other tangible things that identified your answers. All statements relied upon in your first set of interrogatories. All documents that you'll attempt or use as exhibits or introduce. Well, they've already put them in there. We know that they're going to use. They listed out what they were using. Her own Instagram account. Maybe they should just subpoena Instagram. All documents relied upon by expert or retained by you, or notes, draft journals, and other documents referring to the defendants, or other documents. This discovery request seeks all information necessary for defendants to test the veracity of the plaintiff's responses, to discover and prepare their case for trial. But if they're using her social media accounts, if you've ever been convicted or pled guilty of a criminal offence, again, what does that have to do with a lawsuit? If you've been a party to a claim, lawsuit, bankruptcy, workers' compensation proceeding, judgment, Louise, hey, or any proceedings in the last 10 years. Hey, 7M can say if you've ever been party to a claim or a lawsuit. Her list will be interesting. Could you identify each and every social media post plaintiffs have made regarding or referring to defendants, including any drafts? They've already done that. These interrogatories cannot possibly be objectionable insofar as they seek matters that are a matter of public record. They also seek, yes, that's right. Next, defendants seek information related to business and employment practices, also damages that the plaintiffs are squarely placed at the issue of virtue bringing a lawsuit. So they want all institutions. Of course. Well, we saw that before, Will. This one. It says a motion to compel, motion to compel. Here they've point 1, they've asked to compel, but point 2, they want costs for the motion for dismissal. It's a copy and paste. It's a copy and paste. Anyway. So they want all the employment policies and best practices, not limited to content and routine creation, access and management of employees' social media accounts, communication with individuals not affiliated with 7M or Shekinah Church International. Again, they've brought up Shekinah Church, not suing. Identify all past and present employees and contractors of 7M. List. They want the names, date of birth, address, phone number, and terms of employment. List the names and contacts of all in 7M dancers during the relevant period and describe who pays for their housing. Full employment files of each and every. All right, here's a question for you. Do you think that these are reasonable? They want employment files for every one of 7M's former and current employees and contracts, including all their personal details. All documents and communications related to employment terms, best practices. Plaintiffs claim defendants made such false statements regarding to the participation of plaintiff in the Shekinah Church International. They didn't, did they? Hang on. I don't think 7M has actually referred to the church, other than the fact that Robert Shin is part of the church. I don't think that this is even. So this is identify or residential commercial property. It says plaintiffs claim that defendants made false statements regarding the participations of plaintiffs in the Shekinah Church International. They didn't, I don't think. Yes, that's right, Holade. It looks like she's trying to get the proof. They want all the residential and commercial real property owned by the plaintiffs and their affiliate organisations, but not included to Shekinah Church. Describing detail the process of accepting tithes, gifts and donations from members of Shekinah Church, 7M dancers and anyone else. And explain first gifts and man of God gifts. List all businesses, including location, wholly or owned in part, who's a member of the leadership of Shekinah. Shekinah is not injured. All full accounting and all full financial accounting and tax returns of Shekinah. Balance sheets, profit statements, and yearly tax returns. Wholly or in part of anyone who is a member of leadership of Shekinah Church. Now we're starting to get into. And as far as I'm concerned, a lot of this stuff is not even relevant to the case, in my opinion. Documents sufficient to show any. Well, the church hasn't sued her. Documents sufficient to show any contributions, donations, tithes, or other gifts given to Robert Shin, 7M, Shekinah Church, or any other organisation affiliated with Robert Shin. All documents, communications regarding Mission 2020, including but not limited incorporation documents, names, and so here she's trying to get her evidence. All documents and communications regarding any other business owned, created, or filed or funded by plaintiffs, including but not limited to incorporation documents, names, and amounts of investors and financial records. All documents and communication, including prophesying material created or provided by Robert Shin or her associates. Real estate information is a matter of public information, a public record. These interrogatories and document requests may be relevant to determine the interrelationship between plaintiffs and the Shekinah Church International, a matter placed in controversy by a plaintiff's complaint alleging that the defendants made false statements regarding the connection. I don't think they actually brought that up. That's right, Holade. I don't think she'll get them. I think, and you can see why 7M has gone, we want these, we want all of this information. That's saying to the judge, if you want the information, we want this protected because we don't want all of this blasted over social media. Okay. So then they want documents related to other organizations such as Mission 2020 that may show connections between plaintiffs and Shekinah Church International that would escape detection through more direct inquiry. That's a KJ word. Defendants have sought information necessary to test plaintiffs' claim that defendants' social media activity has resulted in a loss of influence and revenue. And so now they're saying these are the interrogatories. Hello, Bo. Well, and don't forget, remember that the judge had said that on the face of what she'd already seen, it could be deemed that some of the stuff she stated was defamatory, and she's not defended it. So they want all the companies and organizations that have paid or sponsored 7M. Okay. Identify all the companies, organizations, and clients who've hired 7M. I think this is why the chart of allegations has nothing about the church. That's right, Will. And if you want to really look at it, 7M have actually been very clever with the way that they've done this, because a lot of these document requests will actually get thrown out. And again, she's not defended it. She's not filed a defense to talk about why there's a connection. She wants documents to show compensation paid, including attributable to social media activity, documents sufficient to show compensation paid, attributed to booked performances or 7M dances, documents to show compensation from any and all sources paid to the plaintiffs, a full financial accounting and tax returns of 7M, complete ledgers showing full receipts of all donations, tithes, gifts, and incomes for the plaintiff, including the source of these amounts, the dates are received, and whether anything was provided in exchange of them. Well, yes, that's right, Holade. All 7M has to show is that since she's opened her mouth, that these contracts have been cancelled. And don't forget, she's gloated about it as well in recent days. And I'm waiting there'll be a document filed. I'm certain 7M will respond and will say a lot of this isn't relevant. However, to further prove that we need this, here's her gloating. So they want documents sufficient to show the income and expenses of James Derrick, including but not limited to his tax returns for the stated period and any statement showing child support paid during that time. What does child support have to do with the allegations? I don't remember 7M talking about, I don't remember James Derrick saying that So they want to show her, she's on a fishing expedition. A document sufficient to show each company paying and having paid 7M or its employees or affiliates as an influencer or advertising partner. All documents or statements supporting the claim that you have incurred 50,000 or more in damages because of defendants' alleged actions, and documents. Information regarding information regarding James Derrick's child support payment is relevant to A, the plaintiff's claim that defendants made false statement that he did not pay some or all of the child support he was obliged to pay. 2, James Derrick's claims relate to damages. The remainder of these requests is related to remaining damages claims. I don't think he did. I'm going to have to go back and have a look at the amended claim. But everything that I've seen has been defendants have sought information related to the claims of emotional distress, identify emotional consequences, identify or then they want a list of all therapists, counselors, psychologists, psychiatrists, and other mental health professionals that they've seen. Oh, since 2012? Shouldn't that be 2021? I think 7 of them actually excluded KJ's post that KJ so KJ can recruit. Yes, that's right. They didn't put that in. List any other mental health diagnosis and their respective treatment regimes. So they want to know who you've seen since January 2012. List of professionals, counsellors, psychiatrists, diagnosis. Then they want copies of medical records, charts, notes, records, prescriptions since 2012. You know what I'd be saying to you, KJ? Go take a long walk off a short cliff. She's wanting evidence for everything she's ever said and not being sued for. Yes. Well, this information is sensitive. Plaintiffs have placed these matters in controversy by bringing the lawsuit alleging emotional distress. Some document requests explore the claims that the defendants made false statements that the dancers were not paid for their work. Documents sufficient to show compensation or wages paid, unless it's supposed to be 2021. And again, it's another really big error, including to its dancers, lease agreements for 7M dancers, all documents and communications related to content creation, dance routines, planning, proof of, not limited to process for selection of music sets, clothes and choreography, all documents showing work schedules and hours worked by 7M employees and contractors, including to meetings, appearances, performances, content creation. Well, the plaintiffs may express outrage that the defendants accused them of they haven't. What? Here, look at this. While plaintiffs may express outrage that the defendants accused them of participating in human trafficking by bringing suit, defendants are entitled to discovery relevant to the defence of truth, but you've not filed a defence. Finally, plaintiffs claimed that the defendant made defamatory statements regarding the marital status of Miranda and James Derrick. Accordingly, defendants sought information that would prove defendants' statements were false or establish a defence of truth. They want their marriage. This information is unlikely to be sensitive and is directly related to claims made in the amended complaint. This phrase here's got me. They're entitled to discovery relevant to the defence of truth. But they've not filed a defence of truth. They've not filed a defence of truth. There's been no defence of truth filed. Show me where, KJ, if you're watching, please point out to me or anybody where they have filed. I got myself so worked out, I kicked myself out of StreamYard. Oh, are they? That's interesting. All right. Somebody tell me where there has been a filed defence of truth. All right. Plaintiffs have failed to show good cause exists for an issuance of a protective order. I think they have. Well, so they're quoting the here. So they're saying, so it says they may make an order which justice requires to protect a party or person from annoyance, embarrassment, oppression, or undue burden of expense, including one of more of the following: that the discovery not be had, that discovery be made on specific terms and conditions. That discovery. So here's all the reasons why. After a deposition, after being sealed, opened by order of court, it's conducted with no one present except persons designated from the court. No, but she only filed. No, she didn't file. She filed a response to the default judgment. She still hasn't filed a. She still hasn't. Okay. So I don't know, and I'm getting kicked out at the moment. So someone's not liking me sharing this stuff. I'm getting kicked out. So I apologize. Right. Plaintiffs seek an astonishing broad protective order that would sequester the interrogatory answers and responses to document requests in counsel for plaintiff's office and prevent Ms. Paulson from accessing these documents, allowing only her attorneys to view them but not make copies. Yes. So her whole objection is that she wants to see them. The plaintiff's contend is because defendants have posted personal contact information about plaintiffs and disseminated depositions from other cases on their social media accounts. Plaintiff's memorandum supporting its motion for protective orders does not identify the material they characterize as their personal contact information. The material the plaintiffs claim the defendants posted about another case consists of a few pages of trial testimony and a page of deposition testimony and what purports to be a witness statement of some kind. There is no evidence that these materials were subject to a protective order. In fact, the defendants' posts indicate that they are public documents available on PACER. Defendants did post that discovery is about to get real. Defendants did not post that they intend to post sensitive information they gleaned through discovery on their social media posts. Nor is it reasonable to infer such intent from fair reading of the post. Parties to defamation suits are entitled to obtain discovery that is relevant to the claims asserted in pleadings. Defendants are entitled to obtain discovery as plaintiffs' claims that the statements made by the defendant were false. Assuming arguendo, and despite the lack of complete showing of good cause, the court finds that a protective order is appropriate. Such an order should be narrowly tailored, consistent with the defendant's rights under the First Amendment and the need for due process. Defendants must be allowed to participate fully in the discovery process and provide meaningful assistance to their attorneys. Oh, I thought it was about providing meaningful assistance to KJ, because that's what she said. That's what it says. It would plaintiffs seek that would sequester interrogatory answers and responses to documents requesting counsels for plaintiff's office and prevent Miss Paulson from accessing these documents. My whole point is, why does she need to access them? Why does she need to access them? Why does she need to sit there and read them? For this reason, stated above, the defendant's motion to compel must be granted and the plaintiff's motion for protective order must be denied. Well, if if this Jennifer Moore wrote that document, I'd be very worried. Right, so this is her declaration. So she's a licensed attorney and one of the attorneys on record for Katie Joy and Without a Crystal Ball. So she's saying, please find attached Exhibit A, first set of interrogatories. B, copy of defendant's request to produce documents. C, copy of court record receipts showing that the documents were served on the plaintiff. And D, some correspondence between the attorneys. Further, your declarer sayeth not, pursuant to that I declare under the penalty of perjury that everything I've stated in this document is true and correct. Okay. So here's the first set of interrogatories, which we've said what we want, which, as I said, a lot in my opinion is not even relevant for the case, but just to prove that her fishing exposition is correct. I'm going to get to that. Wow. If the lawyers from 7M, you're more than welcome to, these people here. Okay, here is defendant's request for documents. Why? Oh, that's in, oh yeah, no, that's all right. Yeah, so as I said, I don't know. So Robert Shin, so it's all about, I don't know why. And right, so it's dated October 5. So C. Here we go. To assign to judge, service only. First set of service only, not sent, not opened. Not sent, not opened, not sent. Service only. Served, no. So this is the 5th, not served. Hang on. So they've not been served here. It wasn't served. Service only. Not served. Oh, okay. Exhibit C. Submitted date. So they submitted it to the court, but they weren't served. Then defendant required for proof for production of service only, and they weren't sent on that day. So they weren't served on the 5th. Okay. D. On October, we filed a motion in this case. The motion was filed due to the sensitive nature. We will not be responding to any discovery documents until an order has been issued on the aforementioned motion. Is that the only correspondence they've got? So that's all they've got. So they've not put in there that there's a response. So 7M told their lawyers, we're not going to respond until it's been KJ. Oh, dear me. I've got a feeling that this is going to be a big fat waste of time. So what's your thoughts on it? I'm very concerned. I'm very concerned, to be frank. Particularly, I mean, they can't even say that they weren't even advised. That they weren't advised. It's not as if 7M ignored it. They wrote to them and said, "We have filed this. We're going to wait until it's been decided upon before we move further." Like, hello, it's just baffling. What are your thoughts? And as I said, we've seen one movement about the human trafficking. Apparently, they're going to use the truth defense, right? Yeah, I just don't know. I know. Well, isn't it funny? Well, see, this is Holly. This is because she hasn't filed a defense. 7M don't know what documents they need to prove, and they're probably going to ask for the sources. Now, the sources are probably not going to want to be named, so there's a bit of a problem here. So yeah, I'm just. Well, I think it's supposed to be Holly. Motion. It's supposed to be motion to compel. She's wanting the fees for the motion to compel, but it's a copy and paste job gone wrong. And I'd be highly embarrassed if it was me. I would not have put my name. I would not be able to put my name on that document. And if it did get through and I picked it, look, I know that mistakes do happen, but mistakes like that don't happen. There are occasionally typos, but that's just a really big mistake, because if you look at it, okay, if you look at where it is, and didn't she incur the costs? Motion to compel, see, this is, so point one, so they wanted the court on the 26th, and awarding defendants their costs and attorneys. This is the motion. Remember, oh, thank you, Bo. Lovely. Oh, lovely. Yes, thank you. Oh, I really appreciate it. Remember, she lost. The thing is, you can't get costs if your motion was denied. So she lost the motion to dismiss. The only ones that are entitled to ask for costs are, in fact, the people that won the motion, which is 7M. So the fact that, and it says motion to compel, if you look, Paulson without a crystal ball, motion to compel, a notice of motion and motion to compel. It's a copy and paste gone wrong. Because the first thing that the judge may ask is, why on earth are you asking for costs for a motion that you lost? It doesn't work like that. This is going to be a really good time. The 21st of November, I'm going to have to, be the 22nd, early hours of 22nd of November. I'm going to have to sit up and watch. It's going to be fascinating. Not only that, they've spelled her name wrong. Oh dear. If you have a look, so if you look up here, I'll just enlarge it again so you can all see. Up here, Michelle, Michele. Do you really think that, I look, those types of mistakes are easy to make. I will admit that, okay? But when you're already on the back foot, when you've already had your motions denied, and on the back, that you want to make sure that everything that you do, A, doesn't annoy the judge, and B, is really spot on. So that's failed. Anyway, that is where we are with all of this. Where's my StreamYard's gone? I'm having huge problems today. Well, they are, as I said, and that's a bit like the putting the motion, confusing the motion to dismiss and the motion to compel is actually a big mistake, particularly when you're asking for your fees to be paid when you lost it. I mean, that's nothing more than cheap. So I had seen some comments on Twitter that it was possible that, maybe the lawyers, come on. Well, she's filed a motion. She's filed a motion for them to compel discovery. But yet filed evidence where 7M had said that they weren't going to respond to any discovery requests until the judge had ruled on it. That is actually in their evidence. It's in their evidence. 7M's lawyers wrote and said, due to the fact we have a motion that needs to be decided on, we won't be talking about discovery. So, hello. And then they filed a motion to compel. So you tell me. Oh, this is on a completely different issue. But did you know, this is not related to KJ. This is just some light relief. All right. I don't know if 5 lions escaped from the zoo last night. Don't know why that's there. And they're now back in their enclosure. Look at this. No, that's right. She said so. Yes, some tigers, lions escaped from the zoo last night, and they had to they were roaming free. That's funny. Yes, so they escaped last night, talking about escapes. So yes. So anyway, they've been rescued. They've been found and put back in their cages, and I think the police were involved and everything. So anyway, so yes, so that's the latest. So for those of you that have just joined, we went through the latest documents. There's a new lawyer on hand. She apparently seems to be a family lawyer. So at least we're dealing with people that are alive now, I guess. She seems to be a family lawyer. She's putting these latest filings, and they're essentially they've asked for a motion to compel discovery. They've stated in there that one of the they've asked for all the details for the church, which isn't suing them, and one of the big things is that they've stated that the human trafficking claim is a truth defence. So, but yet has not filed a defence, an official defence. So, and remember, it was the court that put the notice of default because of the fact there has been no defence filed. So the fact that she has still not filed a defence claim, you know, rather than trying to worry about the motion to compel, I'd be trying to get a defence, getting a defence in there, because at the moment she still hasn't defended the claims, and 7M have no idea what she's going to argue and have no idea what to ask her for discovery other than just the sources that she has, you know, where she got this information from. So, and some of the stuff that she's asked, I think are unrelated to the claim. And I mean, in Australia, they'd be deemed a breach of privacy. There'd be no way. And often, it is actually often the case in Australia that stuff like birth certificates and marriage records are actually sealed or kept from public record. And it's also not unusual for discovery to occur in a lawyer's office with the lawyers taking notes. And it's also not unusual in Australia that the client doesn't get to see what the discovery is. They have to trust their lawyer because you're paying your lawyer. It's your lawyer that works out whether the information in the that they have is bad or not. And it's the lawyer that generally deems the strategy. So for KJ to say, or for it to have in there that the reason why the protective order can't happen is because Katie Joy can't view the records, to me, is not a good enough reason. That's my opinion. And I would like to attend the trial. I'd like to go to Minnesota to attend the trial in person. That would be good. Do it as a law student case study. Well, I'm looking to do some research. Maybe I can research the differences in defamation in Australia and the US. I don't know. I'm going to do research. It's two units of study, and then allows me to go do my PhD. I thought I might become a anyway, I'm thinking ahead. But anyway, I want to thank you all for joining me. Thank you all for all your support and your love and your care. I'm not amazing today. I worked yesterday at the Melbourne Cup, which was a horse race, and my body's not pulled up very well. Hence why I'm like half asleep, really. I'm supposed to work tomorrow. I still have to decide whether I want to work tomorrow or whether I think about my health first. I think I might have to think about my health. But anyway, so so thank you for watching me. Please hit like and subscribe. I will keep you so you'll have to just sorry, I've just lost my train of thought there. But yeah, I'll just keep you all updated with what's happening with this lawsuit. And I thank you all for watching. If you could hit a like and on your way out, that would be great. Thanks. I'll catch you later. Bye.